So we're clear though.
Yeah.
I'm going to sign it. You're going to submit it to state police. If she finds out it's going to cost the township money, then we're just going to come back and talk about how much is too much.
Good.
Yep.
People versus, is it Moylan? Did I say it right?
Yes.
Appearances.
And good morning, I'm William Mays on behalf of Ms. Moylan. Ms. Moylan, state your name for the record, please. Judge,
Good morning.
we're court this morning for a motion to compel production of discovery. The prosecutor had asked that we adjourn this matter over so that she could have time to review the file and get a response. I did receive a response over the other day. If I understand it correctly, she's essentially not objecting to entry of the order compelling production of these materials, but she is indicating that she can only receive these materials through the Freedom of Information Act, which is unacceptable. I guess I'll let her address it, but the bottom line is under 6.201, you know, we've got these discovery rules, these police officers, whether they're her police officers, or the Michigan State Police, they work for her in connection with this case. And the Kyles v. Whitley, they're required to do more than just, you know, they can't hide all these materials and say, well, it's not part of the prosecutor's file. Michigan State Police are, in my experience, very cooperative if you're contacting the right people, which would be like Mark Fondren or Jeff Nye, who's in charge of the Forensic Science Division, and they won't require a Freedom of Information Act. I was just getting materials, I got a call from Nye earlier this week, late last week, about some electronic data that, again, something that you wouldn't be able to get under FOIA because it would be redacted. Under People versus Jack, there's no exemption for these discovery materials. So, you know, I don't know if we need further analysis of that, but, and insofar as costs, I mean, Michigan State Police, they don't charge me when I get something through a subpoena, let's say. It's only chargeable if they do the Freedom of Information Act. Bottom line is that FOIA is just an inappropriate vehicle anymore now that we've got formal discovery rules in misdemeanor cases.
Response.
We were advised, the township was advised that we could only obtain those materials because they're not in our custody or control, the tax ledger itself, through a FOIA, which I included the memo. I advised Mr. Mays, we're not trying to hide these materials. I have no intention of giving it to them. I just don't have them. And the only way to receive them are through FOIA. If he has all these contacts and he can subpoena, then he's welcome to do that with these very documents he's requesting. So, I mean, and again, I mean, if we go through FOIA, which is what we were advised to do, it should be at their expense because it's the value of the materials he's requesting aren't required for a casing sheet. I don't have to prove or provide documentation about some unrelated suspect that gave a breath sample in October of last year and didn't flow within the time frame and you got an error code. That's not relevant to my casing sheet.
All right. So just recap. You want me to order her to provide something that's not in her possession. I don't know that I've ever done that on any kind of case, civil, criminal, any kind of case. A. B, if this is something you can subpoena it.
If you enter an order,
Right.
I will give her the context that she can submit this to. Jeff Nye, Mark Fondren. And even though it's, you know, when you say it's not in her possession or control, when she says it is, she just doesn't realize it. This is just like that Kyle v. Whitley case. You know, the state of Louisiana said, hey, to the U.S. Supreme Court. If the police don't give it to the prosecutor, then how would we possibly know? And what the Supreme Court held in that case is, that would alleviate almost all responsibilities to the prosecutor if the police were allowed to just do this willy-nilly, number one. And two, it would require them the court to say, well, due process is met, even though the police actively hide.
You're missing my point. You just said you subpoena these kind of things all the time. So why would you even go through the discovery? You used the word subpoena a moment ago.
Production on 35th, just a couple weeks ago for X amount of that. And just so that it's clear, the problem with Michigan State Police right, maybe they're behind, maybe they're trying to get this organized, I don't know. But this data that we're requesting Whereas the prosecutor describes it as onerous and voluminous, it's not. This is stuff that other states, when they have an intox 9,000, readily publish on the internet. So that any person can go and just click, click, click and look through all this data. And be satisfied that a particular breath machine is working or not working. The fact that the MSP doesn't put it online, well, that's their bad. And this is her machine, and the way that I would get this, if we weren't going through just discovery, I'd file a motion to suppress the intox 9,000. Then she gotta bring all these people down here in person and they'll produce these documents. And Mr. Nye was extremely pleased when I sent up in this order, it says you must provide this under 902 whatever.
Right.
With a seal and a signature, and he says, what's the purpose of it? And I said, you don't have to show up in court. And he, oh, that's wonderful. So what we need is an order, and I submitted an order, a proposed order to the
Okay.
court. And
So your,
I'll do it, I'll serve it, because I got.
your experience has been, I think you said 35th, that if you get a discovery order, you submitted it and it's not going to cost the township a thing.
Yeah, no.
All right, so let's just draft the order such that if it's going to incur any costs, we'll take another look at it before she signs a blank check.
Yeah.
Because that's all her only concern, right? That's your only concern. No, but your only concern is it's gonna cost the township money. Right. So,
Yeah, and before we cross that bridge, I would just, footnote that when we come down to cost, I mean, if this is an onerous cost.
yeah,
Yeah, sure, we'll have to come back and
Yeah.
talk. But I don't think.
well, she wouldn't bother coming back to me for a $20 fee.
But when it comes to this is almost like for experts,
Right.
I don't pay for my experts and my.
Right. Right.
A bunch of.
Except she doesn't want her experts.
What's that?
She doesn't want her experts. She doesn't want them.
Do that, sure.
Right. So why don't you just you two have a little bit of conversation, figure out whatever language in the order that protects her checkbook, and I'll sign the order.
Yeah, I mean, come back on an issue of cost if we need to, let's just enter the order.
Okay. All right. We're agreeing on the record that if there's a cost associated and you think it's too much, then just tell state police, hold off.
Yeah, that's.
Do I have a proposed order?
Yes.
I do. Okay. All right. So we're clear though.
Yeah.
I'm going to sign it. You're going to submit it to state police. If she finds out it's going to cost the township money, then we're just going to come back and talk about how much is too much.
Fair enough. Thank you, Judge.
Yeah. All right, but we got to do something with this before he gets it. I mean, there's only one copy.
Yeah, I can do that.
Okay. Okay. Give us just a minute, Mr. Mays.
And as far as next date, we'll just work that out.
It's okay with me. I mean, let's see how long this is going to take.
Only thing, I've got a vacation plan. Trying to protect that calendar.
Sure.
Oh, and Judge, since we're here. That's not your case. Never mind. So,
You're all set. We'll get him his copy and get him on his way.
thanks.
Thank you. Ready on Michael Walker. Mr. Walker, come on up and have a seat. You don't have to jump up. They taught her in law school to do that. Go ahead. Go ahead and have a seat. Yeah. Date and time set for a formal hearing. Are we ready? And Mr. Walker, you ready?
Yes.
Okay, let's get started. Thank you. Officer, watch your step on my incline ramp. Raise your right hand. Swear, affirm, tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat right there. Ready when you are.
Awesome, you can just state your name for the record.
Officer Adam Shannon,
And how many employees?
police officer with the Grand Township Police Department,
How long have you been in for the township?
approximately 7.5 years.
And what are your general duties as police officer in the township?
I'm assigned to the traffic event.
And were you on duty on May 13th of this year, approximately 4:00 in the afternoon?
I was.
And at that time, what were you doing?
We were conducting a school bus detail throughout the township with all the traffic unit.
And what road were you on?
Walter Road.
Is that in our township?
Yes,
Were you in a full mark? And at about that time, did you have the occasion to conduct a traffic stop?
I did.
What happened?
As the school bus was slowing down to release kids at one of the last houses on Halls Road near Willow, the yellow lights were flashing, observed a blue Chevy Trax going northbound on Walls Road. Slowing down, I confirmed it with my radar, so I figured he was gonna stop. As the bus stopped, lights turned red, vehicle continued past.
Okay, at that time, was the school bus stopped?
Yes,
Yes. And, you said the school bus was displaying flashing lights,
yes,
and what color were they?
red.
And what do flashing red lights on the school bus indicate colors?
Stop as the kid were exiting.
And to be clear, the respondent did not come to a full stop while those lights were located,
Correct,
and said he passed the school bus.
correct.
Officer, based upon the traffic violation, did you initiate a traffic stop?
I did,
Did you approach the vehicle?
I did.
Who was in the vehicle?
Mr. Walker,
And you see him in court today.
I do.
Can you identify him based on what he was wearing?
Blue polo.
The record reflect the officers identified.
Noted.
And did you approach the vehicle?
I did,
Did you tell him the reason to stop?
I did.
What was that reason?
That you, went through the red light at, or the flashing red at the school bus.
And what, if anything, did he say to you?
He said that the bus was still moving when he was passing and figured he was.
And
I'm sorry, I missed that. And figured what?
did you get your citation?
I did,
What was the citation for?
for the running of the school bus lights.
And other questions?
Thank you. And Mr. Walker, any questions for the officer?
Just about everything.
Okay, you can step down. Anything else from the people? Your turn. You can stay there. Let me swear you in. Raise your right hand. Swear or affirm that what you're gonna tell me is true to the best of your faith and knowledge, belief?
Yes.
Go ahead.
Pretty much everything he said. I was there, I was slowing down, the bus was still approaching. There was no street or corner that I knew where it was stopping, so I didn't know to stop. As I was approaching, like you said, I slowed down.
Let me interrupt you for a minute. Which direction were you headed?
I was headed north,
Was the bus going north or coming at you?
the bus was headed south.
Okay,
So the bus was headed in the south direction, I was headed north. I did slow down, just like he said. As it kept coming, it was to the point where I was close enough to where I looked up, it was still yellow. I proceeded past it. And that's it. I looked up, it was still yellow, I never saw a sign come off the side, and I proceeded past it. And that's the only difference of it. I went to look for video of it, and it was deleted already. If there's 60 days, I guess they roll off. It's within like a few feet boundary of, it was still at me, and I was in the nose of it. When I looked up, it was still yellow. As I got on the side of it, was it probably red? Yes. I don't know how much further it went before it flashed red or when it went. When I saw it be yellow, so I proceeded past. And that's the only difference.
just Mr. Walker. Okay. Any rebuttal?
Well, I do. Can I call the officer?
Sure. You're still under oath, Officer Shan. Go ahead.
Where did you blue Chevrolet vehicles?
I thought before he was even, as he was still approaching him, but,
And about how far would you estimate that?
probably 40-50 feet.
And you had him in a clear vision enough so that your radar was picking up the fact that he was slowing down.
Correct,
And it's your testimony today that when he passed that school bus, the lights were flashing red.
correct.
And you were able to see that based upon your view of the vehicle, this is the other lane.
Correct.
I have other questions.
Where were you located?
I was driving behind the school bus.
All right. So could you tell? I'm trying to figure out the wording of this. In relationship to the bus, do you know where Mr. Walker's car was when the bus lights started from yellow to red?
From what I can tell.
Do you understand that question?
Right at the nose when it started turning red.
Okay.
I did ask him too, what do yellow lights mean on a bus? He said slow, prepare to stop. So he did acknowledge that yellow lights do mean slow, prepare to stop.
And he had slowed. Okay. All right. Do you have any questions for the officer?
Not in the least. It's the same thing. It's within 10 feet. That normally I would still do the same thing because like he said, I was still at the nose, probably in that general area of when it turned. If I was at the nose when it changed, I could have slammed down the brakes, yes. But I would have been already, to me, I was at that point, so I proceeded past it, to clear anything else that was around it and not slam on brakes. But we're within a couple of feet range by the sounds of exactly what he's saying and what I'm saying. As it's coming, how close was I to the front of it and able to stop? Like he said, I did slow down as I was. Came to that point, so I proceeded past it.
Okay, all right, you can step down. Any other questions? Any argument? Yeah, go ahead.
Was going down, it did have vision and borders. He chose not to, when the red lights were flashing, and went through those stops school bus, he could ask me to find him responsible.
Okay. It's been a long time, hold on a minute. It's been a long time since I've actually looked at the statute. The requirement is that he not pass when the red lights are on, correct? So I think we all would agree that there's at some point where the transition from yellow to red, there's got to be some discretion in there whether or not the driver stops or doesn't stop. How do we make that? And I'm just trying to think this thing through. So I'm going to ask if it's all right with both of you. I just want to get the officer's impression. Yeah.
My normal thing when we do these details all the time.
Yeah. Nothing new.
I observe the vehicle pass the driver's area of the bus, like towards the middle of the bus, and it turns red. Usually I let that, that's okay, but he was towards the nose of the bus, plenty of time to stop, and just like the yellow light, just level pairs.
Yeah. What do you mean? But what do you mean by towards the nose of the bus?
Like right towards where the engine.
Like nose to nose as they're coming? Like lined up?
Right in front.
Yeah.
And then my thing is my grace period.
That's a good way to say it. Yeah.
If you're past the middle part of the bus, I'll.
Right. Because I'm assuming, because in your mind, that would not be a safe stop at that point. Okay.
Then you're stopping essentially right where the kids are going to be.
Okay. Okay. All right. Questions?
I somewhat agree, but again, I was at that point
Right.
that when I looked up at the nose, it was still there.
Yeah.
I mean, I'm not disagreeing with them, but
No.
I would have stopped on the side.
No.
But I have stopped on the side, but to me, like he kind of said, once I was at the nose, and to me, it was still moving. So I didn't know, it wasn't
Right.
like we were at a crossroad,
Right.
that, oh, they're gonna stop at the corner. They were stopping in a driveway or something, so I didn't know if it was.
Right.
If we're still moving, I'm like, I don't know if he's stopping here, do I stop and then it goes past me? Or do I just, or nose to nose, do I proceed past?
Okay. Anything else? All right. I'm going to find you not guilty. I think you violated the rule technically, but I'm putting myself in your shoes. Okay. First of all, I love it when a guy comes in and does exactly what you said. It's like I'm not arguing with the officer. I just had a different interpretation of what was safe than he does. Because that's kind of what I'm hearing. So I first of all, I like to reward people that don't come up here and blow like a bunch of smoke at me, right? The other thing is, like I said, I'm trying to put myself in your shoes. And I don't think, from what I'm hearing, I don't think for a minute you did what you did because you were in a hurry, or you did what you did because you were, not concerned with the safety of the children, or all those other reasons people do stupid stuff like pass a school bus. I think you made a legitimate call that he thinks is wrong, and I can agree with him. I could agree with him. But I'm not going to find you. I'm not going to hit you with this, giving you everything that I just heard. So not responsible. But you posted some money, so you're going to get money back. Thank you, Officer Sheehan.
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society.
In this heated custody dispute, the judge delivered a powerful warning about honesty and transparency in court. Miss Huey was told that court rules apply to everyone, even those representing themselves. The judge made it clear that evidence cannot be hidden and then revealed at trial. Any information not properly disclosed could be excluded entirely. The court also denied a temporary parenting plan change, stating there was no proof of immediate danger to the child. As tensions rose, the judge ordered full discovery responses within 30 days and warned both sides that courtroom procedures must be followed without exception.